I recognise the Honourable Member Dennis O'Rourke.
Thank you, Mr Speaker. This bill, the Local Electoral Amendment Bill, should probably be renamed the John Banks Problem Avoidance Bill, because that's a big part of it. But the other main provisions of the bill amend the Local Electoral Act 2001 to improve consistency with the Electoral Act 1993 regarding electoral donations and expenses, limit the amount or value of anonymous donations, refine the definition of anonymous and donation, enhance the obligations of candidates for the disclosure, reporting and recording of electoral donations, something I think Mr Banks should note very well if he can remember to do so, and to produce penalties for non-compliance. But as I will say later, it does fail to address some important issues, and a previous speaker has mentioned some of those. But something else that the bill does do in clause 15 is to require that a candidate profile statement include whether or not the candidate's principal place of residence is in the local government area in question. That's something that people have wanted to see for quite a long time. And the word area means a ward or a similar division within a local council's boundaries. It does not preclude, of course, a candidate from standing if living outside the area, and it does not preclude him or her stating what connections he or she has with the area. In fact, it would encourage people with a connection other than residence to make it clear why they should be elected to represent the area in question. Of course, some people who do live within the area may in fact have been there a very short time and not have a genuine connection with it. So voters will need to be aware that just living within an area is not necessarily a genuine long-standing connection with it. But the most important new provision concerns anonymous donations, and this has been the source of continuing problems, as we know, especially the John Banks issues with claimed anonymous donations to his last Auckland mayoralty campaign. And as a result, there is widespread concern about what appears to have taken place concerning Mr Banks' return and anonymous donations. The bill contains several new sections about donations. We now have a new definition of what an electoral donation is in new section 103A, which clarifies what goods and services are to be included and establishes a threshold of $300 for the purpose. It excludes labour provided free of charge, as of course it must, and the Select Committee has recommended another provision requiring candidates to disclose a return of electoral donations and expenses for each office for which the candidate has stood in the election. And also that a candidate should be required to specify the campaign to which an anonymous donation of over $1,500 was designated. The bill, as introduced, did not specify any particular limitation period for prosecuting offences under the Act, because the offence of filing a false return and arranging to circumvent the $1,500 limit on anonymous donations involve elements of fraud and dishonesty, and so a relatively long time frame for investigation and prosecution is needed for that reason. The Select Committee has therefore recommended amending clause 36 by adding a new section which specifies the time frame for prosecuting the new offences in sections 112D and 103I as 6 months from the date on which the prosecutor is satisfied that there is sufficient evidence to warrant the commencement of proceedings, but of course no later than 3 years after the offence was committed. Now, the Banks situation demonstrates why that time frame is needed. And concerning the John Banks problem, at least the one we can address in this bill, the bill does address the one matter which the John Banks electoral return from 2010 local body elections have highlighted and have revealed a gap in the existing legislation, allowing persons acting for candidates to call donations anonymous which they did or ought to have known were not in fact anonymous donations. Section 103F says, and I quote, "If any person involved in the administration of the affairs of a candidate in relation to his or her election campaign knows the identity of the donor of an anonymous donation exceeding $1,500, the person must disclose the identity of the donor to the candidate." I do worry a little that it will be necessary to prove actual knowledge under that section, which may be difficult, and that perhaps the words "or ought to have known" should also have been included. But the committee did not agree with me on that. Nevertheless, this is a satisfactory new provision which will help solve the bank's problem as I think of it. The bill also provides in section 103.8 that an anonymous donation may not exceed $1,500, and I quote, "and that if an anonymous donation exceeding $1,500 is received by a candidate in relation to an election campaign, the candidate must, within 20 working days of receiving the donation, pay to the electoral officer responsible for the conduct of the election to which that campaign relates the amount of the donation or its value less $1,500. Close quote. And also, and I quote, if an anonymous donation exceeding $1,500 is received by a candidate who is seeking election to more than one office, the candidate must designate one election campaign for election to one office for which the donation will be used. Close quote. Now, section 103I provides for offences relating to contravention of section 103H. And it says, and I quote, "A person who enters into an agreement, arrangement or understanding with any other person that has the effect of circumventing section 103H 1 or 2 commits an offence and is liable to, on conviction, to a fine not exceeding $5,000. And a candidate who contravenes the section would also commit an offence and be liable to a similar fine." So that's a good step forward and does help solve, I think, the bank's problem. The bill provides for postponement of a local election, and I note that the Green Party has expressed concern about the new powers given to the Minister of Local Government to adjourn elections in the case of natural disasters and other such emergencies. The bill would allow the whole election to be postponed by order in Council by up to 6 weeks at the discretion of the Minister. The Greens' concern is that it gives the Minister excessive powers. But I note that section 106, subsection 6, says, quote, "Before recommending the making of the order in Council, the Minister A must be satisfied on reasonable grounds that the order is necessary to ensure that the adverse effects of an emergency, whether local or national, or of anything referred to in section 73, 1A to D, do not deny electors a reasonable opportunity to cast a valid vote, nominate a candidate or accept nomination. And B, must have consulted every local authority and electoral officer that will be affected." So I think that subsection 6 does sufficiently limit the Minister's discretion about postponement and would preclude the sort of ECAN situation that the Greens seem to be most concerned about. There is, however, one very serious defect in the bill, and it's the one mentioned by other speakers, and that is the gap concerning third-party campaigners able to receive donations and to promote a candidate without that candidate's permission. Now, there hasn't been time to address that so far, but I do trust that the government will see, before this bill comes into force, that that matter is addressed and is included in the legislation. Mr. Speaker, overall the bill is a good one and does deserve support, noting that it is still work in progress. But it's a shame that work has not been done already. However, assuming that it will be, New Zealand First will be happy to continue to support the bill as amended by the Select Committee.
I call the Honourable Kate Wilkinson.
Mr Speaker, can I say it's a real pleasure for me to take a very brief call in support of the